There is established jurisprudence regarding legal aid in the criminal context, but less in regards to civil law matters. The ICCPR guarantees the right to representation in criminal matters in any case where the interests of justice so require. This is also reflected in the European Declaration on Human Rights. Criminal matters generally involve court proceedings and give rise to fair hearing concerns due to the implicit formality and complexity of adversarial criminal hearings and potential consequence of one's loss of liberty. The Special Rapporteur on the Independence of Judges and Lawyers considers that legal aid should be ensured in both criminal and non-criminal cases. The EHRC provides for an entitlement to a fair hearing and determination of civil rights. In Airey v Ireland, the European Court of Human Rights determined that there is a right to legal aid for civil proceedings where it is indispensable for an effective access to the court. However, this is a high standard. The UN Human Rights Council has been less willing to find the right in the context of civil proceedings. The right in civil proceedings has so far been limited to where a person on death row seeks constitutional review of the irregularities in a criminal trial.
When is the right breached?
The state must provide counsel that is effective. There has been no breach found by a state on account of general incompetence or poor decisions made by counsel. There will be a violation where it is manifest to the judge that the lawyer's behaviour was incompatible with the interests of justice, or that there has been a miscarriage of justice. The European Court of Human Rights requires that states take positive action to ensure the applicant effectively enjoys his or her right to free legal assistance.
In Artico and Italy, the European Court of Human Rights found that the right to free legal assistance was not simply satisfied by the formal appointment of a lawyer, requiring that legal assistance must be effective.
The right may also be violated where an appeal is withdrawn by the assigned counsel without consultation, where the assigned counsel is absent during any stage of proceedings, or where the assigned counsel is not a qualified lawyer. Access to legal aid is a non-derogable right. It is indispensable for effective access to courts and a fair hearing. States are required to implement a national legal aid model, but have a margin of appreciation regarding the nature of the system adopted and the eligibility criteria. States are also required to take positive steps to ensure that the right can be effectively exercised by making the relevant information available. This is particularly pertinent for marginalised groups who are often unaware of their rights. There are also requirements of quality, namely that state-provided counsel possess the requisite qualifications and training necessary for the services provided.
The Victorian Charter of Human Rights and Responsibilities require legal assistance in the interest of justice. However, decades of budget cuts have meant that people in Victoria unlikely facing imprisonment are not eligible to apply. In addition, family law matters only have entitlement to assistance during pre-trial preparations and how to self-represent in court. The High Court have also stated that legal assistance is not always necessary in the interest of justice.
There will be a right to legal aid where it is in the interest of justice and a person is of insufficient means to afford legal counsel. The right applies more generally in criminal law, and despite the Special Rapporteur's assertions that it should be guaranteed in criminal and civil cases, there is little case law to this effect.